All right. Hello, everybody. We're live on Facebook tonight. Just doing a sound check. If someone from my crew can tell us how we're sounding. All right, looks like we're good to go. Welcome everybody to Whitson Law Firm's Everything You Wanted to Know, but we're afraid to ask about child support modification proceedings. Good evening. I'm so glad that you're here with us tonight. I'm Debra Whitson. I am the founding attorney and owner of Whitson Law Firm in Elizabethtown, New York, and the CEO and founder of Mediated Online Solutions, which serves people everywhere because we are a virtual mediation service for separating and divorcing couples and people who are coupling and want to have cohabitation or prenup agreements. So you can check us out. We'll give you details about that at the end. My background is as an attorney in New York State for 30 years. I am a mediator, a co-parenting coach, a collaboratively trained attorney, and owner of the two businesses that I just talked to you about. And with me tonight is my colleague in the Whitson Law Firm, senior counsel to the firm, Martin Cohen. Martin has himself a wealth of family law experience and mediation background. But Martin, I'd like you to take a second just to introduce yourself and talk a little bit about what you bring to the table tonight with your experience.
Thank you, Deborah. So I bring over 2 decades worth of legal experience, a lot of it in family law. I represented children for over a decade, and that helps bring a nice complement to my practice in helping couples with divorce and custody proceedings. I like to think of my practice sort of like, if you will, a chess game. Logical, practical, looking at the long road rather than quick knee-jerk reactions. We want to get a good solution for our clients.
I love, Martin, that you have that experience as having been an attorney for children. For those people who are outside of New York State, you may know phrases like guardian ad litem or law guardian for children. In New York, we say it's the attorney for the child appointed by the court to represent the child in certain contested proceedings that affect them. It's very, very helpful, I think, when you're helping adult clients now, separating parents and parties, to have had the real life experience of getting the perspective of young school aged and even high school aged children who are affected by those proceedings. So so glad to have that experience as part of our repertoire at the firm. But tonight we are here to talk about child support modifications. And I, of course, because I'm a lawyer and Martin's a lawyer, we have a bunch of legal disclaimers. So we're going to start with those. The first thing is we are here to pass along information, answer some questions that you have submitted ahead of time. But as you just heard, Martin and I are admitted to practice law in New York State. So all the information we share tonight comes from our perspective and experience about New York laws. So if you're in another jurisdiction, another state, or even another country, because where we are located, we're very close to Canada, but you could be tuning in from anywhere in the world. Just make sure that while we might give you some things to think about if you are in another jurisdiction outside of New York, you should not rely on our information as being relevant or applicable in your jurisdiction. You're going to want to consult somebody where you are about the laws that are governing child support and child support modifications in your area. The second legal disclaimer that I have is that nothing we are doing tonight is creating an attorney-client relationship. We actually, frankly, don't know who most of you are, and may have no idea who's tuning in to recordings and things like that. So we are not giving legal advice to anyone. We're trying to give you some information, answer some questions in a way that might be helpful, or steer you in a place where you can find good resources. But in order to have information that it will serve you, and a professional like Martin or me, we would need to know the details pretty much in depth of your unique situation before we could be considered as giving anyone advice about their particular legal needs. So with that said, If you are in New York and you are looking for legal services or legal advice, we're happy to have you call the Whitson Law Firm or visit our website and contact us that way. We'll put contact details at the end of this in the comments or the thread of this broadcast. And if you are interested in mediation services, we do mediate family support issues, child support, spousal support, etc. If you are willing or interested in looking at voluntary mediation to address those issues, modify existing orders, or create an existing agreement on support related matters, you can contact Mediated Online Solutions, and we'll put that information in the comments for you as well. And since we are virtual mediators and we provide services by video conferencing, we can serve you for mediation services anywhere you might be located on the planet. So that's it for the disclaimers. We want to dive right in and give you some really useful information, I hope, tonight. So Martin and I are going to spend a little bit of time just kind of giving you the lay of the land on the basics of child support modifications from our New York law perspective. We'll talk a little bit about common situations that arise that we want to bring up in case you're facing that situation. And then many of you have submitted in advance questions that you wanted to submit to us. And we're going to go through those after we spend a few minutes chatting with you and giving you some background information on child support modifications in a general way. So I hope you'll stick around with us. We're going to plan to be on for about an hour. If the questions take us a little longer, rest assured we'll try to get through all of them. And if you can't stay with us for the whole time, don't worry. If we have your contact information, we will email you a link to the recording. But the recording will be up after the Facebook Live, not just on Facebook, but we'll put it across our socials, and there'll be other places that you can pick it up and find it and replay all of it or part of it as it suits you anytime you'd like from the convenience of anywhere you are. So with that, I'm going to turn it over to Martin and have Martin start by giving you kind of the basic lay of the land of what's involved in a custody modification matter in New York courts.
Well, not a custody modification, but a support modification.
Oh, I don't know why I'm doing that. It's late in the East Coast for me. I don't know about everybody else. I'm sorry. Child support modifications.
So we're looking at a very specific part of the law. You have a support order, and it's in New York, and you're looking to modify it, or we're looking at the modification standard or the practice, the statute. So we wanted to start by giving you the lay of the land as to the New York statute, because in New York, you can only modify support under generally these three guidelines. Number one, if your income or your ex's income, if one of the parties' income changed by 15% more or less, if it increased by 15% or decreased by 15% or more, that would be a reason to petition to modify support, and it would be something that the court would consider. A second reason to modify that the court allows in New York is if there's a passage of 3 years or more since the last order was entered. So if you have that passage of time, whether or not there's been an increase or decrease in income, and you're just interested in possibly changing the old order, you'd be able to file a petition to modify. And I guess the biggest reason that people file is the third reason. If there's a substantial change of circumstances, you can go to court and modify. So when the court, a lot of people ask us, what's a substantial change of circumstances? So it's not that you feel that the order is unfair. It would have to be something really significant. So an example might be that you lose your job, or one party finds themselves going to prison, or you have a child that becomes emancipated. So those are the three. And when I say emancipated, I mean a child ages out. So in New York, the age would be 21. In other states, it's a different age. We're focused on New York. So in New York, the age of emancipation when child support stops in New York is the age of 21. So that would be a reason to modify. Those are the three reasons. There may be other situations, and we're going to talk about a lot of them, but all of them have to in some way fall under these three guidelines in order for you to end up before a judge in family court to modify child support. So I just mentioned emancipation, and I think it's useful before we go on to at least look into what emancipation is, because some of the questions we had talk about emancipation, and we should at least understand what we're talking about. So emancipation is when the New York Family Court and the legislature says, that's enough, there's no more child support required by the party paying. So one way to be emancipated is that your child becomes the age of 21. Another way, less common these days, is that your child marries, but it still can happen. Obviously, one way that this would also stop is if there's the death of a parent or the death of the child. The most common reason that we see in our practice that a lot of parents don't think about when they're entering into an agreement of some sort, or they've entered or they've gotten an order from family court when their children are young, is that some children, when they graduate high school, don't get married, and they don't go to college. They end up moving away from home, renting a room with a friend, and they start a job somewhere because they want to make it as young people in the world, and it's very responsible of them. But that is a reason the court will consider that child emancipated under that circumstance, under that fact pattern. And we do see that happen. So those are the reasons that a court would consider a child to be emancipated, and emancipation is a reason to file, because that's a significant change, to file a petition to modify support. I think those were my issues to give a lay of the land. Debra, do you have some issues?
Well, I want to just add on a couple of things. I do have other issues and topics I wanted to address, but I wanted to highlight, it could probably deserve its own mini presentation, but New York, not that long ago, enacted a law that said support can last up until age 26 now in New York if you have a disabled young adult child that you are caring for. And that's very specialized, and the rules around when that can apply to your situation are very specialized. But if you find yourself in that situation, that the child is disabled and needs the support of parents beyond the age of 21, just know that that is permissible now in New York under certain circumstances. And then I wanted to just highlight another thing, and it kind of falls under the umbrella of Martin saying when a child goes out on their own and makes their own way in the world, they can be considered emancipated. A way we frequently see that is the child entering into the military service before age 21. So if they're in the military service, the military is taking care of them. They have housing, they have salary, and so on and so forth. So they are emancipated by virtue of that, even if they're 18, 19, or 20. So, but I wanted to talk about a couple of sort of out of the statutory framework kinds of situations that in all the years that Martin and I have been doing this, which sounds like more than 50 or so now together combined, things that come up often enough that it's worth mentioning here, because maybe there's some of the people in the audience who are facing or are about to face these kinds of situations. So one thing we often get asked, or we see in proceedings and support modifications, is when one party gets fired from a job. So if you voluntarily leave a job and you take a lower paying job, that even if your income goes down by 15% or more, which is one of the statutory thresholds for revisiting child support potentially, the court may not be impressed by your voluntary reduction in income. But getting fired from a job, sometimes people think that that's a gray area. Maybe it is a good reason to go back and say, now I can't pay support because I was fired. But if you were fired for cause, I mean, literally fired, not laid off or something like that. If you were fired because you weren't performing, you were violating company policies or something like that, that could be considered something that was your responsibility and your actions that led to getting fired. So your request to have a reduction or a cessation or ending of your child support if you have no income because you were fired may not impress the court, and you might not prevail on your argument. In fact, you very well may not prevail on your argument to get a reduction in support under those circumstances. Now, I don't know what your community is like, but in the region where Martin and I practice law in upstate New York, people often have a bunch of jobs. Sometimes there are really good seasonal jobs that pay very well. And then in the off season, people take other kinds of employment. So it's not uncommon around here for us to see people regularly holding 2 or more jobs. And then, in the economic situation that our country is in right now with inflation and the economic challenges that were presented by the COVID pandemic here in the States anyway, people are taking on extra jobs just to make ends meet and, keep their head above water or be able to help put kids through college or whatever. So sometimes we see people who have entered into agreements or had orders put in place when the payor in this situation was carrying multiple jobs. And then as time goes on, right, if that happens when the children were babies or toddlers, and then as time goes on, this person has been carrying multiple job responsibilities for many years, they may get to the age or just after time say, how long do I have to be in this indentured servitude, so to speak, of working multiple jobs now that I'm getting older? Maybe the work is harder for me to perform physically, that kind of thing. And just know that there's no real clear guideline in our law or our case law in New York on that. Many family law cases are very fact specific to the unique facts and situations that a particular family and standing in front of the judge or support magistrate are encountering. So the fact that you just no longer want to carry on 2 or more jobs probably isn't a substantial change in circumstance. But if you had a health condition that indicated that it was wise for you, it was medically recommended to not carry on so much work any longer, that possibly could tip the scale in favor of a substantial change in circumstances that might warrant your support being modified or adjusted downward in that situation. Another thing we see very commonly is the challenge of 1 or more parents being self-employed. So if somebody's on someone else's payroll, they're on their employer's payroll, they're getting a pay stub at the end of the year, they get a W-2. That's a pretty straightforward application of our child support laws in New York. We can determine the payor's income or the parents' respective incomes from those documents and their tax returns, which are usually straightforward if you are wage earners on someone's payroll. But when somebody's self-employed, there are a lot of challenges to that. So if you are the parent seeking support and you're going against a self-employed parent, the self-employed parent may not keep good books or records. They may not even consistently file tax returns. Their tax returns might have inflated business expenses in order to reduce their taxable income. They may legitimately take accelerated forms of depreciation on certain assets acquired by the business in a certain tax year that is allowable under the Internal Revenue Code, but may artificially reduce their income, and that can be in certain circumstances recaptured in the child support analysis if the recipient parent, with the aid of counsel usually, can present this to the court, explain this, and talk about the realities of the person's true income situation versus what their business books and records may look like, or their tax return may say are their actual business expenses and their net income. So that presents a significant number of unique challenges and circumstances, and you would be very well advised to get expert legal advice, and you may even need to engage advice from tax professionals to help understand the self-employed person's tax situation, their business records, and the deductions that they have claimed on their taxes, to see where how accurately that tax return truly reflects that payor's income versus perhaps liberties taken on business deductions and the like. What about the people who work off the books? So again, in our unique economy, we have a lot of seasonal farming and orchard businesses. We have seasonal tourism businesses, and those tend to be industries where people may be working for cash off the books. And a lot of times people come in and say, I know the other person is working, but they're going to say they have no job and they have no pay stubs and they have no income to report on a tax return. So that's another level of unique challenge. And there are ways to get at the truth of the situation. So one way is to look at the person's lifestyle and what they say their expenses are just to survive. And if they say they have no income, but they're living off of a budget that would suggest that they needed at least 35 or 40,000 to pay their housing and their food and their gas and their transportation costs, et cetera, then you can make an argument that there must be income to support that lifestyle. We're just not seeing it in any official record, unless, of course, they're living by accumulating debt. So if they have credit card debt that equals how much they are expending to live, then that might be an explanation. But at some point, I think there's a good way to piece together the reality of the situation. If they come to court in new sneakers and they're a regular smoker, and they're buying their cigarettes, but they say they have no income, those are really good things to point out very quickly to the support court. Where are those things getting paid for? How are those things getting paid for? The other options you have with people who are working off books is that New York attorneys anyway have the power to subpoena records and information and to subpoena people to come to court and testify. So if you have some idea of where the person may be working for cash off the books, you could subpoena that employer, you could subpoena people who know that they're showing up at that work site, and such. So don't lose all hope if you're up against somebody who is definitely working on the sly without a reported income. There are ways to sort of piece that together and make sure your children get the support that they actually deserve. And then the last thing before we get into questions, for families with multiple children, maybe it's perhaps most common that all of the children are principally in the custody of one parent for the purposes of child support. And let me pause there and tell you a little about how New York looks at that. In New York, even if both parents share exactly 50-50 parenting time with the children, the higher wage earner, the higher income earner is presumed to be the one who's still obligated to pay support to the lower wage earner. So a true 50-50 parenting schedule will not eliminate child support under our laws, but sometimes we see situations where, for whatever reason, let's say there's 3 children in one household or one family, and one parent has custody of 2 or primary custody of 2, and the other has primary custody of 1. So what do you do in that situation? Who owes who what, right? So it's pretty clear if all 3 kids were in the principal custody of one parent that the payor would pay the prorated or percentage required under our law. In New York, that'd be 29% of their adjusted gross income. But when you're dividing kids across the houses, mom might owe dad for one child and dad owes mom for two. So what the court would do in that situation is calculate dad's obligation for the two kids in mom's household, calculate mom's obligation for the one kid in dad's household, and net them off against each other. So it wouldn't be like dad sending a check and mom sending a check. We would just net that out, see who owes who what, and one amount of support would be going to the other household, unless they zeroed each other out because of the way the parties' incomes fall. So that's a fairly common thing. And the fact that kids sometimes, as they get older or circumstances in the household change, they may switch from the principal residence of one parent to the other. That would be a substantial change in circumstances. If the children were in a particular household at the time of an order and they have changed to be principally living in the other parent's household, that would be a very classic reason to go back and seek modification. So aside from those kind of unique topics, I do just want to say, because I told you at the outset of this that Martin and I are mediation trained, and we have a mediation company, Mediated Online Solutions. At any time, for no reason at all, or for a reason that is unique to your situation, parents can modify their support arrangements and even agree to modify a prior order by voluntary agreement. So you don't need the 3 bases to go back to court: the 15% change in income, or substantial change in circumstances, or passage of 3 years. Anytime you two want to sit down with or without a facilitator or a mediator, you can adjust your modifications or agree to modifications and adjust your obligations or your orders. But in New York anyway, there are very specific things that need to go into an agreement to be binding on the parties. So it would behoove you to get some in-depth advice from attorneys so that agreement that you strike is properly drafted so it's enforceable and able to be turned into an order of the court by agreement as well, if you both wish to have it be an order of the court. I know some families just don't ever need to have their agreements turned into orders and they work it out. But voluntary agreements can become the basis for a New York court ordering the agreement to be an order of the court, provided the agreement meets certain conditions. So with that said, we're going to go down through the viewer submitted questions and hopefully get through all of those in the next 30 minutes. There were lots of them. There were 30 questions. So Martin and I are going to try to rapid fire about a minute through each of these questions. No kidding. We're going to try to cover them in a way that's helpful to you. And if we go longer, we go longer. But Martin, do you want to start off?
Sure. So the first question is, how can modifications be made if the non-custodian's employer refuses to provide employment verification? So if you were listening carefully, you would have heard both of us or one of us say that you can definitely get financial records in a child support proceeding. In fact, that's the very first thing that the court is going to send to the parties or to counsel, is something that's called a financial disclosure affidavit. It's going to require each party to submit a statement of their present financial situation. It's going to require tax returns and pay stubs or other proof of what your wages or income is, because the court wants to get an understanding of what that is. So it doesn't matter whether the employer refuses to provide it, the party's going to provide their source of income. And certainly if there's some unusual situation and you have taken the time to consult with an attorney, your attorney can subpoena additional information. The court will give permission for limited disclosure if there's some unusual situation. Debra, would you like to take question number 2? Sure.
Question 2 is, what if my child's needs change? He's been in a serious vehicle accident. Can I request a modification? So yes, potentially you can. That could rise to a substantial change in circumstances if the accident resulted in additional substantial expenses that weren't in play when your last order was put into effect, or your agreement, if you had a marital agreement. Obviously, this sounds like a subsequent event, and so that very well could be a basis to request a modification. What you're going to want to know there, or be able to prove there, is exactly what are the additional out-of-pocket expenses that go along with the accident and the injury that was sustained by the child. And also probably a good idea, if it's able to be known, how long are those expenses expected to continue, or if they're expected to increase over time and not decrease. What does that look like, so that you're not having to go back to court over and over again as the recuperation or rehabilitation after that accident is ongoing. So the rehabilitation can be more expensive in a short run, but in the long run might later reduce the required expenses to support the recovery from that accident. It's a great question. Martin, you want to take 3?
Sure. What happens if one parent's income has changed, or if they have lost their job? So that's really the most important thing that we see when people are considering filing a support modification petition. And remember what we were stating at the beginning, that the court is going to look at the parent's income has changed. Has it changed more than 15%? Because if it's changed less than 15%, that's not going to be a reason to modify a support order. If they have lost their job, Debra was talking about that earlier. You want to find out, was this did the person lose their job for cause? Was it did they just lose their job due to the market condition? Are they looking for another job? But certainly, if one of the parents has lost their job, yes, that would be a reason to file a support modification petition. Question 4 is, does it matter which parent requests a child support modification? That's a good question, but the answer is pretty simple. It doesn't matter. Either parent can file a support modification petition, and it doesn't give either party an advantage as to who files first or which parent files. The court will look at both parties' income with an unbiased eye towards both statements, financial disclosure affidavits, and all of the finances. The court's going to throw it into the child support computer that the judges have, and the computer is going to come out with a result, which is what the new order should be. Certainly, if there are issues that come up in a support proceeding, the court is going to consider arguments. It's going to consider positions that each party has relative to this. So it's not as simple as plugging it into a computer. Nevertheless, the simple answer to that question is that it doesn't matter. Either parent can file, and there's not going to be an advantage to who files first. Question 5 is, does the state, and here we're talking about New York State, put a limit on how often they will consider modifications of child support? There is no limit. The court will consider support modification petitions when they fit into the criteria that we described. If there's a 15% change in income, if there's a substantial circumstance listed, or if there's been a passage of 3 years. Generally speaking, parents will go back to modify their support orders when it's sufficient, when there's a good reason to do so. And so there isn't necessarily a specific number of times that parents could do that. Question 6 is, do you need to file a formal motion requesting a modification due to a change in circumstances? I would say my answer to that would be yes, only I wouldn't call it a motion. I would call it a family court petition to modify support. If you fit into those categories, you're going to file a support modification. You don't actually have to file a motion. Deborah, I think you've got number 7.
I do. So number 7 is, what if I'm disabled and unable to work? Can my child support be re-examined? And I know you're going to hate when a lawyer says, yes, but, but yes, but if the disability is new, that gives you a substantial change in circumstances. But this is one of those situations where you're going to have to prove the disability. So you may need medical testimony to back up the disability, or a finding if you've applied for disability benefits under New York State or Social Security, and you've gotten an award, then that would be evidence that the disability is acknowledged and established. But you'll bear the burden of proving the disability, and you may, if it's a disability where you're not 100% classified disabled, you may need to argue about, does it render you completely unable to work, or are you able to work but on a limited basis? Or the other party may be coming back at you saying, I don't believe they're totally disabled. They can do light work, office work, not heavy lifting, that sort of thing. So it's not always a straightforward argument, and you will be needing to be prepared to, in this situation, meet the burden of proof of the disability and its impact on your ability to earn an income. If you are, by the way, classified as disabled and you have a dependent child, the child may be eligible for derivative benefits from the government disability payments, particularly if your disability is considered permanent. But in all likelihood, the answer to the question is yes, you probably can get your child support re-examined based on a disability that didn't exist at the time that the last order was entered.
So question 8 is, what are examples of circumstances which may necessitate a change in the child support order? Well, 2 off the top are statutory reasons. If there's a 15% change in income of either party, that's a circumstance that might require a change in the support order. Or if there's been a passage of 3 years, that in itself might be a reason to re-examine the support order. Perhaps this question is asking about substantial circumstances, and we've discussed some of them. Some of them, the last question about a disability, that might be a significant enough circumstance to re-examine the support order. The loss of a job, if one party goes to prison, someone gets a huge promotion at work, and a party gets a promotion. Maybe one of the parties finds that they have to pay child support with another family. That might be a circumstance to revisit the support order. So it's a very general question. There are a lot of factual situations that can come up. The next question is about whether an informal agreement will be recognized as valid or binding by the court. For example, what if my ex promised to pay more as his wages increased? So we talked about this earlier. If there's an informal agreement that the parties have with each other and it's working, perhaps they don't need to go to court. They can just follow their agreement with each other. If they are going to go to court, the court may not recognize it as binding unless the agreement has certain specifications that are required in a support order that would be required by a court's examination of this agreement. So I would suggest that if you have such an informal agreement, this might be a very good reason for one or both parties to visit with an attorney so that that agreement can be turned into a proposed order or stipulation and order that a family court judge would recognize and sign. The next question is, how do the courts determine child support for joint custody arrangements? Well, Deborah answered this question a few minutes ago. In New York, and this is not true in all states, but in New York, if there is a joint shared custody relationship, the higher paying party is going to be the payor and is going to pay the full guideline child support amount required in New York State. Having said that, I will say that in my experience, and I'm sure in Deborah's experience, when attorneys are involved and there is this type of situation, well, let me just put it this way. If you have this situation with joint custody, this is a great time to get an attorney involved to help negotiate perhaps a deviation from the child support guideline amounts. Doesn't always work, but sometimes we've had success with lowering child support by agreement by both sides with attorneys involved when you have a joint custody situation.
I'll grab the next one, Martin. The next question is, are modifications purely to increase or decrease child support, or are there alternative arrangements that can be made in terms of gifts, personal belongings, etc.? I love this question because absolutely not allowed in New York for a court to order unique things about alternative arrangements that many families may be interested in considering. But in mediation or voluntary agreements outside of court, you can absolutely be as creative as you'd like. So I have mediated situations where parents decide that they will maintain a joint account just for the purposes of child support. They'll decide how much each party funds that account and on what basis. So maybe they put in a specific amount each week, and their amounts may differ based on their income and expenses respectively. And then they make an agreement on what is that account is used for. So if it's school close time and they agree on that, they'll use that account within certain limits. So I have mediated and drafted agreements in that fashion, and in a whole manner of other fashions where people want to come up with creative ways to handle support rather than one parent paying a check or having an income deduction diverted to the other, where once it's in the other party's hands, you don't know where it's going and what it's being used for. So you can get very, very creative and very specific to your situation in voluntary situations. But in New York anyway, the court is pretty much bound to determine the party's incomes, determine who's the custodial parent entitled to support, and run the calculations. And they don't get much more creative beyond applying the statutory calculations and the statutory percentages of sharing additional out-of-pocket add-on expenses like health insurance and uncovered health expenses or daycare expenses. So if you want to get creative or be unique, you got to stay away from the courthouse, or get your agreement done first and then bring your agreement to the courthouse and turn it into an order. Martin, can I interject here? There's a couple of questions in the chat and I don't want to lose them. So I'm going to take those and then we'll go back to the series of questions in numeric order. But
Sure.
Someone asked in line, is a child emancipated once they have full-time employment after high school graduation? Does it have to be a full-time position? Yes and yes. So yes, if the child has full-time position or full-time income equivalent, they can be deemed emancipated even if they are still living in a parent's house and they're not living independently. So being employed full-time and not being in school could be a basis to consider the child emancipated. But you should know that employment during the summer recess between high school and college, or on college breaks, even if it is full-time or more than full-time, won't render that child being emancipated. We want to give children and families the opportunity for children to earn money for their continued education beyond high school. So the work that they do while they're still technically a student would not necessarily be an emancipating event. But if they're not going to school and they are working full-time, they very likely would be considered emancipated for purposes of child support. Another question submitted in real time tonight was as follows. I found out my disabled son's father let his health insurance lapse. So I got a revision/modification started. His income has changed significantly. What happens when it goes to a hearing before a judge and he appeals it? So the way the facts are laid out in that question, it sounds like there could be a support violation found if the father of that child was ordered to maintain the insurance and he let it lapse. So there could be a violation launched against that particular parent. But if his income has changed significantly by New York standards in New York State, then it seems fairly certain that there would be an adjustment to the support and perhaps additional contribution for health insurance or any out-of-pocket expenses that were incurred for healthcare for the disabled child when there was no insurance in place. So if that father in that scenario does not like the judge's ruling in New York, if that ruling came out of a family court support magistrate's courtroom, then there is a relatively informal and streamlined and fairly quick procedure called objections to an order of support. It's not as formal and as involved as an appeal would be in the traditional sense of the word, as most of us understand that. If that decision came out of a divorce Supreme Court enforcement action or out of the family court proper, not the support division of family court, then the appeal would be to the appellate division in the part of the state of New York where those parties live. For us, Martin and I and our law firm, that's Albany. So there would be an appellate court in Albany and a very formal proceeding involving typically lawyers having to get transcripts and write briefs and appear to argue the case, etc. And the appellate court in New York on a decision like that would have the ability to uphold the lower court's decision, to reverse the lower court's decision and send it back for a new hearing, or on the right set of circumstances, if there's enough facts in the transcript, they could make a new decision as though they were the trial court. So that's a little bit of a technical legal answer, but I hope that was helpful. So I think I'm up next in the sequence of the pre-submitted questions. No, that's you, Martin, number 12.
Number 12. Let's see. Can you fill out a form order and take it to the judge yourselves if both parents agree, or do you need to consult an attorney? I think we've answered this question a couple of times in different ways. So if you have an agreement, you're going to want to consult an attorney because an attorney can help the two parties prepare a stipulated agreement and a proposed order that meets the conditions that the court's expecting to put into the support order.
Are we on 13? Yeah, okay. Can temporary support be modified? That's an interesting question. This person's probably have been through the proceedings before in New York anyway. So in New York, the petitioner, well, not in a modification, but in a basic child support commencement proceeding, the first time you're going for support, you're absolutely entitled, if you're the petitioner and you are the custodial parent, to some temporary order of support. However, the courts at that stage, that early stage, when there may not be full income and expense information from the parties, doesn't have to strictly apply our formula for determining final child support. So they could pick a number out of thin air. And then when the case is fully decided, there may be adjustments to account for overpayments if the actual final amount of support awarded is less, or there could be arrears that have to be handled and paid in some manner if the final order of support is greater than the temporary order. But can temporary support be modified? Yes, if the proceeding goes on for a long time and there's some reason or basis to have the court reconsider or revisit that. For instance, if you go in on your first appearance and we don't have much information on people's income and expenses, and the court kind of spitballs a temporary order, but then as you exchange financial disclosure affidavits and tax returns and pay stub information, that could be modified if the initial spitballed temporary order turns out to be inappropriate because of now the magistrate knows more about the party situation. So until there is a final order at the end of the case, then yes, the temporary orders that get put in place while the case is going on can definitely be revisited.
So the next question that was asked is, How do I go about modifying child support when my children are emancipated? Does it fall away automatically? This is a great question, and this comes up a lot. And the answer is, well, I'm going to go to the second question first. It does not automatically stop. So a better way of phrasing this question would be, my answer would be, you should modify child support as your child is getting ready to be emancipated. So as you're approaching the 21st birthday of said child, you should consult with an attorney or go straight to family court and file a petition to modify support such that support terminates on your child's birthday. And so that what's also significant to point out relative to that is that if you don't file a petition and your wages are still getting garnished after your child turns 21, or you're voluntarily paying these, making these payments, the court is not going to award that money back to you. So it's important to be conscious about this and to attend to it as soon as you recognize that your child is about to turn 21.
I'd like to add something to that, Martin, because I've seen this
Sure.
in situations. So let's say you have 2 children on the order, and the parties are savvy enough to know that in New York, the percentage of the payor's income for 2 children is 25%. But when one of them ages out, it reduces potentially to 17% if you take action in the court to change the existing order. But sometimes parties will unofficially agree to adjust those things if they know the situation, but that won't be binding. So I've seen it a lot where the payor will say, I know my rights now that the oldest child number 1 is 21. I'm only going to give you what would be my support obligation for one child at 17%. They can't do that technically unless they're in agreement to informally work that way with each other. If they do that, the recipient parent can say they're in violation, and they can be found to be in violation, and then they will have arrears. And if the violation is determined willful, there could be penalties or consequences for that. So I would say don't self-adjust unilaterally if you are the payor when one of the children ages out, because you could get slapped kind of by the court for doing that. As if you don't have an agreement, you don't formalize your agreement out of court, you should file something to have the court officially adjust your support based on the emancipation.
Right. So as we've been saying over and over since the beginning of this live feed, is that emancipation is a very critical issue, and it's a reason to modify support.
Yep.
So the next question that was asked is, do I need to file a financial affidavit with my request for child support to be modified, and how do I go about obtaining one? This is a very easy question to answer. Yes, you do need to file a financial disclosure affidavit. It's the first thing the court looks at and the first thing that the court requires. How do you go about getting one? Well, you can get one from your attorney if you retain an attorney, but either way, you're going to get one from the court. The court is going to send you the financial disclosure affidavit, the one that they require. Sometimes it's a short form, some courts it's a long form, and then you just fill that out and send it in. And I think that's a good answer to that question.
It's an excellent answer. Next up is, how do I serve my ex with a petition to modify support? So please, if you are outside of New York State, take this answer with caution. But in New York, courts will first try to send documents. The court clerk will send documents to a mailing address. And to a certain extent, since COVID, if the parties provide email addresses, they may email the documents as service. But if the party doesn't respond on the first date that it was summoned to court, then the court may require that that party be personally served at that point. So this is a a deviation from the basic rule that you, in any court proceeding, you typically have to personally serve the papers, have a process server, a deputy sheriff, or somebody hand them to the other party. In New York, we start first by trying it by mail. It's probably because just the sheer quantity of support matters going through our court system and the desire to see if they can efficiently and cost effectively push these through without having to spend a lot of money on sending process servers out, scurrying around trying to serve 1 million of these petitions every year. All right, next up is, our income tax documents applicable to child support modifications, and will the courts make their decision based on these documents? So the answer to that is yes, but it could depend. So some people don't file taxes, they don't make enough to file, and some people just, put their head in the sand and they don't file and hope the IRS doesn't come looking for them for many years or ever. So if there is not a tax return to rely on, it's not the end of the world, it's not the end of the case. There are other ways to establish income. But the basic rule in New York State is the parties are if you've signed a tax return, you are deemed to have adopted what's in that return as being complete and truthful and accurate. So you can be bound by what you put in your tax return, and it may be hard to argue that you overstated your income or you didn't take as much business expense deductions as you were entitled to, et cetera. So you could be held literally to what your tax return states as your income. But if the tax return has situation or information in it that looks irregular or non-compliant with the Internal Revenue Code, there may be some arguments to be had that by the party whose tax return it is not. If you are challenging that tax return, you might be able to challenge it, but you can't submit your own tax return and then say that's not really accurate if you signed it and you filed it. What can I expect during a child support modification hearing? That's a great question. So family court proceedings in general are less informal. They're called special proceedings and not civil lawsuit proceedings, so to speak. So the court has a lot more flexibility and less stringent rules for parties in child support cases. In some jurisdictions like ours in New York State, you may have a child support collection unit team and even attorneys from the county Department of Social Services child support unit who will facilitate the prosecution of your petition or facilitate enforcement of child support obligations, and they will facilitate the collection process. So setting up a payment through the state system or payroll deduction or income execution, as they're called. You'll get an online account where you can see what's been paid and what's been sent out to the recipient parent. So there's a lot of services there available to, sort of surround the parties in the child support world. But if you're going in with attorneys, basically your attorneys will prepare you for what to expect at each appearance. So first appearance might be the time to get a temporary order in place. And if you might have a next appearance to see if you can settle or work something out. And then if you're on for a hearing, in New York, we call a hearing, it's less formal than a trial, then the party who filed the first petition technically bears the burden of proof. So they get to go first and put in any proof or evidence or call any witnesses, including the other party, or take the stand themselves. Then it turns over to the other party. They get to put their evidence or proof in. They can testify. They can call witnesses. And then your attorneys will make arguments about what facts are reliable and how the Child Support Standards Act should be applied under these specific facts of the case. And then the magistrate or family court judge may make a ruling right from the bench, and your outcome right there. If your situation is more complex or the court's calendar is very busy that day, you may get a written decision mailed out to you in the mail or email nowadays through the court clerk's office to the parties and their attorneys. So your attorney would prepare you if you are going to take the stand. You should know, in advance what questions are going to be asked and that kind of thing. If you're going it alone, you have a general lay of the land, and the testimony from the parties will be very informal because there will be attorneys doing questioning and objecting and so on and so forth. And typically the family court judge or the magistrate will ask a lot of questions in that situation directly to the parties so that they're sure they have all of the information they need to make the proper ruling in that case.
Can I jump in with some thoughts on that? Yeah. So Debra mentioned that it's an informal hearing, and we found that, especially with support matters, it can be quite informal. So you may have an appearance in an actual courtroom where it's informal, as Debra was discussing, or you may have a virtual appearance. They hold some of these, the support magistrates, some of them still hold these cases sort of as a holdover from the COVID era virtually. And then we've also seen some magistrates, judges in the family courts will hold these hearings by telephone. And it's important to point out that they're informal, but even at the very first hearing, a magistrate judge may take testimony of the parties, even at the very first hearing, testimony that's limited to finances, that's limited to income, and where the children live, solely to get a temporary order of support in place based on the judge's initial understanding of the case. But it's just interesting how informal that some of these proceedings can be.
Yeah, that's good points. So there's a bunch of questions that really kind of boil down to one particular topic. So I'm gonna consolidate a lot of the remaining ones because we're now at 8:01, and I promise you we're wrapping up in a few minutes. You're going to want to stay to the end because there's some good resources and free stuff that we will give you. But so there are a number of questions that really come down to when does the support modification take effect, and can it go back retroactively? So that is really important in New York. The party who's petitioning for a support or an adjustment to support is entitled to have it go back retroactive to the date the petition was filed initially with the clerk of the court. So even if it takes 6 months or longer in some jurisdictions, in some cases, based on how busy the courts are or how complicated your case is, if you get an upward modification, that will apply retroactively to the date that you filed. If you're the petitioner who said, I need relief and I need it downward, the modification will go back in time with certain limitations on the ability to expunge or get paid back for overpayments of support. But if there is an upward, it definitely will go back in time, and you'll usually there's a plan put in place by the court to if the lump sum amount of arrears that have accumulated because of the retroactivity is so large that it would be unduly burdensome on the payer, they may add on a little bit in every payment going forward until the arrears are caught up and satisfied. So that's important to know. So if you think you're entitled to a reduction, you want to get in as soon as you think that you have a basis to do so, or you've consulted an attorney who says you do, you want to get that petition right in. And if you are entitled to a modification upward, same thing. The sooner you get it in, the more, if you prevail and succeed on your upward modification, the more time it will cover going back to the date that you filed. And then there's a couple of questions that generally fall into what if there are short-term changes in my income or my income varies a lot. So those are both really kind of interesting scenarios, and I'll address them kind of together. So in a short-term emergency, if it's so short-term that you might not get relief before your situation turns around, you may not have a good avenue for assistance from the courts unless you can get that filed on an emergency basis. And usually you need an order to do that. So you would file what's called an emergency application or an order to show cause, which would expedite the process and will get you your relief sooner. If you have, as many people do when you're self-employed especially, or you're seasonally employed, you may have up up and down trends in your income. In that situation, you might succeed in prevailing upon a court to average your income over periods of time. So if you're taken to court for support at a moment when your income is high, but if you look a year back or you project a year forward is going to be much lower, you could try to have the court look historically at like 3 years or 5 years of tax returns and run an average, so you avoid having to come back in the low periods and modify. But if there is a lot of variability in your income, you may have to come back on a year-to-year basis or whatever to readjust or re-examine if the court won't sort of take a longer term view and try to even that out by averaging your income over time. So I think that covers all of the questions submitted, including the ones that came in the feed on Facebook Live. Well, we've been talking about this tonight, so thank you. If you stayed with us the whole time, I appreciate you hanging on 5 minutes extra. I got a few things to announce when I wrap up. So everybody who has registered for tonight, we have your contact information, and you will be receiving by email, assuming that you did provide your email when you registered, a free copy of my book, Divorce Like a Pro, A Better Way to Break Up. It covers how to approach divorcing, but the concepts in there, including discussing mediation and voluntary agreements, would apply to any family law related matter, including support modifications. So that will hit your inbox, or you'll get a link where you can download the book at no cost, and you'll be getting more information on how you get your free copy of that book. If you know other people who would benefit from it and they did not join us tonight, it is available on Amazon, Divorce Like a Pro, A Better Way to Break Up. Also, keep your eye out. We do these Facebook Lives generally once a month, and we change the topic up over time. So we've addressed custody, we've addressed mistakes to avoid when divorcing, we've addressed getting financially prepared for divorce, we've addressed grandparent rights, and we'll keep coming up with topics and coming here free to you, hopefully offering good information and value to you all, because we appreciate you. So coming up, most recently, we're going to be doing a webinar on Facebook, and the topic is 10 critical mistakes to avoid when filing for divorce. You might also want to look for information on our websites. We have plenty of free downloadable resource guides on various topics. We have blog articles and lots of short videos. You don't have to sit through an hour of a Facebook Live on many, many topics relevant to family law. So the websites will be in the comments below. It's whitsonlawfirm.com and mediatedonlinesolutions.com. And you can catch me. I'm a regular guest on Alyssa Panitz's The Divorce Hour podcast. And those are recorded and replayed on Spotify, and she has a lot of other guests and a lot of other content from other professionals, all related to divorce and how to survive and thrive through your divorce. So you can look for those recordings and keep an eye out on Alyssa's podcast ads for future appearances by me on the podcast. And coming soon, there's a podcast called Going Solo for people who have come out the other side of divorce and are now navigating their new life post-divorce. And I will be talking about the value of cohabitation agreements if you don't want to jump right into another marriage, but you want to jump right into romance and cohabit with somebody. There's some good legal tips there surrounding why it's so smart to have a cohabitation agreement. And so stay tuned. We'll be posting on all of the law firm and Mediated Online Solutions social sites, including here on Facebook, when that is going to be broadcast for you. Right now, we don't have a broadcast date for that podcast. So thank you, everybody, for joining us tonight. It was our pleasure. Thank you, Martin, for being my co-presenter tonight. And I hope we see you back here on our next Facebook Live or Facebook webinar. Good night, everybody, and good luck with your support modifications.
Good night.